The world is a troubled place. We must find time to save the human race. Love, unity, and empathy has no place among the human race. In this transition, when we live in love and harmony and show respect with unity, only love can set us free to fight injustice wherever it be. Just said the hungry must be fed, but man can't live by only bread. We have the future in our hands. Let's take the trot to the promised land. Jamaica, Ethiopia, America, calling, Nyankopong, calling, Nyankopong, calling, Nyankopong, calling, from the middle of the graveyard to the center of the sea. Our ancestors, are you and me? We are the great ones. From the beginning of time, we have the heart, the soul, the body, and the mind. Calling, Nyankopong, calling, Nyankopong, calling, Nyankopong, calling. United we stand, divided we fall. All for one and one for all. Some never know themselves until them back against the wall. Jamaica, Haiti, Nyankopong a call, calling, Nyankopong, calling, Nyankopong, calling, Nyankopong, calling, Praises to the great ones, praises of our nation. Yeah. Oh yes, I say, united we stand, divided we fall. All for one and one for all. Some will never know themselves until they're back against the wall. Nigeria and Nigeria, the Asians wanna call, calling, Nyankopong, calling, Nyankopong, calling, Nyankopong, calling. Living demons calling, calling, the global warrior calling, ancient warrior calling. Yep, Grand Rising, another day, another challenge, another victory. Sorry for the late notice, but you know me I multitask last night. I'm a bed almost 3 o'clock. But of course, the work never done. Big up to the kings inside, Ambassador Nigel, Brother Earl Jackson, and of course, Brother Kareem. Danny was here with us. Hopefully he returned. All right, here's Brother Danny. Grand Rising, Brother Danny. Yes.
Yeah, Grand Rising.
Yeah, man. Yeah, we're going to see how much brothers and sisters come over Today, Nana Chanel is in the building. Yo, yo, yo. Hey, like my madam secretary, last week, our anti here right early. Nana Chanel, right rising. How you doing?
I'm good. I'm good. I'm good.
Like a bite of more than your food. I know, I know. We need some tips how to raise teenagers. As me tell you, boy, Nana, boy, you can bring them in the world, but you can't control them.
I'm having that
Ah.
problem with my last two.
No, I'm if you tell them, me a boy
I'm having
11
that
year old.
problem with my last two.
Me have a grand rising doctor. Nice
I'm
to see you.
rising.
Yes, is the first to getting a taste of Nana Chanel. Teaching, he is here.
The
Nana
first,
Chanel, go ahead.
Oh, thank you.
yes, the
Yeah.
first four was very easy to control, but the last two, man, they're killing me.
Boy, yo, I have a 11-year-old here where I know I love him, but boy, sometimes I forget tough love. I mean, I like the tough love, but boy, something I tell, something I try to tell them. When my grandma usually bust my ass, me usually say she wicked, but it was some own good cause boy, she never beat out some of them dirty ways there. And I think would have come out to be who I am so humble and nice because as children they have this rebellion in them because they know that what we're doing to them is domesticating them in some shape or form and they're rebelling.
With the boys, I had to use embarrassment and tough love with the boys.
Yeah.
I don't know.
Hey, I am. I have to be there for him now because he's entering the teenager. He's coming into manhood. That is when they need us the most because we're transitioning into responsibility. But we'll get into that later. I think Crystal is on her way and Sister Abina is coming today. Um, what the police tell in background?
I'm about to turn it down.
All right, good to go. Listen to it, as I was saying, you have never been in a class with our madam secretary. She is very versed in human human psychology and human resource when it comes on to human rights. She does teach us a few things. Um Nana, I found a tape that was put in the class about the UCC. I was going to allow you to, if you wanted to have that played. It's a very informative thing with the UCC. It is detailing everything about our rights. So if you want, you can have that at your disposal. But I don't know if you had put a teaching plan together already, so I won't interrupt if you have that intact.
I do have a plan,
Okay,
um,
it is yours.
but we can watch that UCC and
You want to watch it after or before?
we can do it after.
All right, then. Without any further ado, the platform is yours, Nana Chanel.
Okay.
You're gonna share screen if you want to. I'm here.
Yeah.
You want to? All
Yeah.
right, the screen is yours.
Wait a minute. Why isn't my thing coming up? There you go. Can everybody see my screen?
Yes, I just.
Can you guys see my screen?
Yes, I can see it.
Okay. So I've been doing some homework. I made us a little slide to travel.
Okay.
And is the screen legible to everyone?
Yes, you're
Yes,
on the screen.
yes, it is.
Okay, right to travel, traveling, driving. Come on now.
Ah,
Okay. All personal property is the product of some man's labor, whether the owner has acquired it by his own labor, by inheritance, or by exchange. His interest is a vested right of the most unlimited character. He does not hold it by any favor of the state, and in consequence of his possession of it, he has assumed no peculiar obligation to the state. He has the right, therefore, to acquire it in any manner that he pleases, provided in doing so he does not interfere with or threaten the rights of others. Um, and this is on your right to travel. I have a few, what do they call it? A few words to go through
site.
here. First is citation. What is a citation? A citation is a writ of the court addressed to an officer of the court and commands him to do certain things. Vocabulary, that's what I meant to say. Words to go through. Next is commerce. Wait, am I on the right subject?
Yes, you are. Right.
Okay.
Right. Travel.
Next is commerce. And from the Latin commercium means trade, trafficking, from come together, merchandise,
Merchandise.
from commerce pertaining to trade, meaning done for the sake of financial profit, commodity from commodite, benefit, profit, from the Latin word commoditatum. Then we have constructive contract. All these words that all these vocabulary words that I'm bringing up, they're gonna be appear somewhere later on. Constructive contract. Constructive contract is where duty defines it instead of the contract defining the duty to be. Constructive contracts are fixed law adopted to enforce the legal duties by actions. Contract where no proper contract exists, expressed, implied. And there's a case law citing constructive contract, Graham versus Cummings, Herzog versus Herzog. And you'll see as we go along, you'll see I've got a lot of case laws, and these are all public records that we can look up, and if anything strikes your interest, you can just copy these case laws down. Matter of fact, I'll provide everyone with a copy of the slides towards the end of the course because I'm not done yet. Conveyance. According to Merriam-Webster, 9th edition, convey is to transfer or deliver to another, to cause, to pause, to to cause or to pass from one place to or person to another. Transmit. Conveyance is an instrument by which title property is conveyed. And we often call our vehicles conveyance as well.
Yep.
Next is driver. One employed in conducting a coach, carriage, wagon, or other vehicle. So we're not drivers unless we're employed to do one of these things, and unless we're employed to then collecting funds from our traveling, then we're not drivers, we're travelers.
Mm-hmm.
And that's Bevore's Law Dictionary version. Black Laws Dictionary, 3rd edition version is one employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. So it all has to do with one being employed. License. The law applied to motor vehicles. Webster's Dictionary. License is authority or liberty given to do or forbid any act, especially a formal permission from the proper authorities to perform certain acts or to carry on certain business, which without such permission would be illegal. And according to Bevore's Law Dictionary, 3rd edition, in governmental regulation, authority to do some act or carry on some trade or business in its nature, lawful but prohibited by statute, except with the permission of the civil authority, or which would otherwise be unlawful. In other words, a license is a what? That's your permission. Operating motor vehicle. It's exercising control over the vehicle, although not at all time in the driver's seat. Private. Merriam-Webster's 9th Collegiate Dictionary says that it's intended for or restricted to the use of a particular person or class, belonging to or concerning an individual person, company, or interest. From the Latin word privatus, set apart, belonging to oneself, not of the state, used in contrast to publicus communis. These are all Latin words. Originally, stem of private, to separate, deprive from, privus, one's own individual, from Old Latin pre, before, meaning not open to the public. Next is privilege, from the Latin word privilegium, law applying to one person, privus, individual, plus lex, law, a right or immunity granted as a peculiar benefit, advantage, or favor. Next is public road. A roadway existing for the free and unrestricted use of all common people is a public road. And that's also cited in the case of Henninger versus Peary. Next is register. Where's my mouse? Register from Latin word registra, to record, literally to carry back from plus career, carry, bear. Merriam-Webster Ninth Collegiate Dictionary means enrollment. I think we did this on the last class. We had the register meaning enrollment as well. Next is service. Services for which the price charged is required by law to be determined or approved by or to be filed, subject to approval or disapproval with the United States or any state or any department, agency, officer, or official of either, as in the case of transportation service. We have 3 more words to go. This is traffic. Business or trade, commerce, transportation, the movement of vehicles on street or highway. Commerce, trade, sale, or exchange of merchandise, bills, money, and the like. Was someone saying something? Okay. Commerce, trade, sale, or exchange of merchandise, bills, money, and the like. Passing goods or commodities from one person to another, equivalent in goods or money. Commerce, trade, sale, or exchange of merchandise. Sounds like it's all the same. The passing or exchange of goods or commodities from one person to another for an equivalent in goods and money. The of transportation on a route as persons or goods, the passing to and fro of persons, animals, vegetables, or vessels along a route of transportation as along a street, highway, etc. Next is transportation. The act or business of moving passengers and goods, the removal of goods or persons from one place to another by a carrier under Interstate Commerce Act. Transportation includes the entire body of services rendered by a carrier in connection with the receipt, handling, and delivery of property transported, and includes the furnishing of cars, the removal of goods or persons from one place to another by a carrier. And it is a law case stated here, Interstate Commerce versus Brimson. And then according to Black's Law, 6th edition, the movement of goods or person from one place to another by a carrier. Next is travel or traveler. travel is to journey or to pass through or over as a country, district, road, etc., to go from one place to another, whether on foot or horseback, or in any conveyance as a train, an automobile, carriage, ship, or aircraft, make a journey. And traveler, one who passes from place to place, whether for pleasure, instruction, business, or health. And we have another law citing versus state. So let's begin. Streets and highways are established and maintained primarily for purposes of travel by the public and incidental uses. And I wanted to make note that this was taken from a book that I put in the classroom on what put that in the class chat about 2 weeks ago. So everything here was taken from that book, and that's about 160-page book. So I didn't want to use the book itself. I just want to take things from the book to use in class because it took us a while to get through an 80-page book. So there's another book that's double that size. We never get through that in 6 weeks. Does anyone have any questions on the vocabulary words before we move on? Nope, no questions. Okay. Travel is a generic and broad term. The phrase incidental uses in the above citation means the use of the highways as a means of personal gains. Discussed later on, it is now and has been known that traveling is of two basic categories: those who travel in a personal capacity for pleasure and those who travel the public highways incident thereto for profit. Traveling for pleasure connotes the movement from one place to another for one's own enjoyment, as in the case of visiting friends and relatives. However, it is undisputed that the use of common highways is also for general purposes. Those common purposes may include, but are in no way limited to, traveling to or from the places doctors, veterinarian, grocer, hardware store, beach, picnic, coffee stand, work, movie, funeral, convenience, smart, school, families, homes, dinner out, sporting events, etc. Traveling for a distinction may also be made between private carriers who transport their own property for compensation and those who transport their own property without compensation. The use upon the public highways of motor vehicles engaged in transportation for hire may be prohibited, restricted, conditioned by the controlling public authority. Highways are public avenues for use by the entire public for their private and personal purposes, and the use of a highway for profit and gain may be restricted. Here's another case citing Stevenson versus Binford. Based upon the fundamental ground of the sovereign as the plenary control of the streets and highways in the exercise of its police power, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the right of the citizen of use to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right, the latter is an extraordinary use. As to the former, the legislative power is confined to regulation. As to the latter, it is plenary and extends to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right, but a mere license or privilege. I'm going to take 2 minutes and get some water. Is anyone have any questions? All right, just give me 2 minutes. Let me go get some water.
All right. While Madam Secretary has gone to get some water, the lessons is about traveling. All right. A lot of us do not differentiate the difference between traveling and driving. And I think that is where a lot of us get into entanglement. The first thing an officer, when they pull you over, they ask for a license, driver's license, and licensing. This is what Nana Street is teaching about today, the difference between traveling and driving. So the wording, how she's putting it, how to answer a peace officer or a police officer, should I say, when they approach your vehicle, some of the right, some if they threaten that they're going to write a citation, that is, we need to know the inside of how to deal with these agents. So Nana is back. I wanted to just point that out. You may continue, Madam.
Thank you.
Well,
The use of the highways for purpose of transporting personal property for hire by the ordinary means is incidental to and consistent with the primary purpose of their establishment, these highways, and is therefore a proper use of the absence of any restricted regulation. Such use is not, however, one which may be exercised as of right, but is a special or permissive use. A street is a road or public way in a city or town or village. A way over land set apart for public travel in a town or city is a street, no matter by what name it may be called. It is the purpose for which it is laid out and the use made of it that determines its character. As the way is common and free to all people, it is a highway, and it is proper to affirm that all streets are highways, all highways are streets. The existence of a public highway creates a public easement of travel, which permits the general traveling public to use the highway at will. All persons have an equal right to use highways for purposes of travel by proper means and with due regard to the corresponding rights of others. Hence, a traveler as such may occupy and use any part of the highway he or she desires when needed by another whose rights thereto are superior to his own. The right of locomotion has also been held to be a part of the liberty guaranteed by the due process clauses. That's also cited in U.S. versus Lobb. The United States Supreme Court has held that the right of locomotion, the right to remove from one place to another, according to intention, is an attribute of personal liberty. And at the bottom, there are different case laws citing this and backing up this one statement. The public easement includes every kind of travel and communication, movement of transportation of persons or property which is reasonable and proper in the use of a public highway or of a particular portion thereof, with all means of conveyance which can be introduced with a reasonable regard for the safety and convenience of the public, and without inflicting upon the owner of the fee an injury differing in kind from that imposed by use and improvement or ordinary public travel, and embraces all public travel not prohibited by law or by the dedicatory restriction on foot in carriages, omnibuses, stages, sleighs, or other vehicles, including motor vehicles, at wants and habits of the public's demand. The public is not confined to the use of vehicles in use at the time when the streets highways were established, but may use such other reasonable means of conveyance as may be discovered in the future, provided they do not exclude the proper use of the highway by other modes of, or kinds of vehicle, or tend to destroy it as a means of passage and travel common to all. A citizen has an absolute right to choose his mode of conveyance, provided he observes all of the laws of the roads. Case law Swift versus Topeka. One may transport his goods over the highways in wagons, automobiles, or other vehicles loaded thereon or therein as he may deem best, provided that in so transporting them he uses the care that a prudent man would use, care commensurate with the dangers created by his undertaking. The right of a citizen to travel upon the public highways includes the rights in so doing to use the ordinary and usual conveyance of the day and under the existing modes of travel. The term travel is a broad term having two legally distinguishable meanings, one being the statutory definitions listed herein, which specifically clarify that commercial travel is accomplished when a person undertakes to deliver using a public highway that which has been purchased and accepts a fee for such delivery. The other being normal everyday use, as discussed above, by way of traveling public roads to connect oneself with the community. As the Eggert Court points out, traveling the highway is not based on the Commerce Clause. The right to travel is a right applicable to interstate as well as interstate commerce. Inasmuch as the right to travel is not based on the Commerce Clause, it does not depend on the interstate nature of travel. Rights such as the right to travel, which involve personal liberty, are not dependent on state lines. Both travel within and between states are protected. Have any questions so far?
No.
The right to travel is a well-established common right that does not owe its existence to the federal government. It is recognized by the as a national right. Undoubtedly, the right of locomotion, the right to move from one place to another according to inclination, is an attribute of personal liberty, and the right ordinarily of free transit from or through the territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution. No person shall be deprived of life, liberty, or property without due process of law. The courts at many levels have firmly established an absolute right to travel. State by applying commercial statutes to all who would use the highways has deprived the common traveler of the right of liberty without cause and without due process of law. Yet one individual has been given yet not one individual has been given notice of the right to travel the roads and highways, yet let alone before signing the driver's license application or the application for vehicle title to defend against the potential loss of the right to travel wheel on the highway. The travel must be armed with the knowledge that there was an intentional concealment by the Department of Licensing. Since the state alleges alludes that one give up the right of traveling in order to exercise the privilege of driving, the statute regulation cannot stand under the police power or due process, which must be exposed as oppressive by misapplication and misrepresentation to deprive the citizen of rights guaranteed by the United States Constitution and the state constitutions. First, it is well established law that the highways of the state are public property and their primary and preferred use is for private purpose, and that their use for purposes of gain is special and extraordinary, which generally at least the legislator may prohibit or condition it as it sees fit. Therefore, it is concluded that the citizen does have a right to travel and transport property up on the public highways and roads, and the exercise of the right is not a privilege. Driving is not traveling, absent express language to the contrary and proof of allegation. Notwithstanding the static eccentricities, no conviction may be lawfully sustained or upheld. I'm going to stop at this slide for now, and we can discuss what we already went through. stop share. Go back to StreamYard.
Yeah, it seems to basically boil down to that last sentence there. Absent. What? Just
I
read
didn't
that
hear
again
you.
for me. Absent is. It basically boils down to what was said in the last sentence. You know.
The last sentence, the part that says,
Yeah. Yeah.
notwithstanding
Yes.
the static implicit,
No. Absent.
no convict.
I can't see. Yeah. Yeah. Can you elaborate on
Oh,
that exactly what that means?
driving is not traveling. Absent express language to the contrary and proof of allegation.
Yes, that's what I'm talking about.
Because what is driving?
So what does that mean in layman terms?
Driving is commercial. Traveling is not. The corporation
Yeah, I get
cannot
that
come up
part, but
with
I'm not.
any. Say it again.
I get that part, but the part where it says absent without, you see, I can't, you haven't got it up, so I can't see it. I'm just trying to get those words ready set in my head so I know exactly what that means. Show me
Okay.
that sentence again.
You want me to show it? 1 second. Go
Yeah.
back to sharing.
Okay. Danny, she was saying that driving and traveling is two different things. Driving is when you're doing commerce on the road for a third party. When you're traveling and doing your own conduct of your own business, that is not driving. In other words, there's no form of exchange in the trade barrier for a third party. But I'll put back up what you asked Nana to explain. There it is. Grand Rising Crystal. Thanks for coming.
Grand Rising, everybody.
Yeah. Is it that you're asking Nana to explain? Therefore, it is concluded that the citizen does not have a right to travel and transport in his property upon the public highway and road, and the exercise of the right is not a privilege. Driving is not traveling. Absent express language to the contrary and proof of allegation.
That's the
Notwithstanding
part
the
I don't understand.
driving is not traveling.
So the
Absent
corporation, no matter how they say, no matter how they try to tell that when you're traveling, you're driving, they have no proof of such allegation to say that you're driving or collecting any, any pay or doing
doing
commerce instead of what you're actually doing, which is traveling.
Danny, do you understand?
There's no
Danny?
there's
Yeah,
no
that seems to make
words in
more sense
which
now. It's just the way it was written.
Okay.
okay.
Where it says absent express language to the contrary.
Meaning that an agent cannot presume that you are driving because you're around a steering. Because an automobile is like a donkey. Do you drive a donkey or do you travel on the donkey? So you're travel in an automobile. You're not the one mechanically doing work for the automobile. And secondly, you're not doing any commerce. Not because you're in an automobile mean that you're selling goods. Understood?
Yeah. So
All right.
that makes the whole thing that's clear. That makes the whole thing seem more and more like a major scam when them pull it on us.
Well, it is a scam, but it is for you to stand up, and that's why we encourage brothers and sisters to activate your estate. Don't just own the estate. You have to activate. All right, Nana, I yield back to you.
Thank you. Any other questions? Okay, Rascalites, you want to play the video now? We have like 7 minutes.
Sure, sure. This is a very interesting video. All right, let me establish this, and I am also going to put this inside the classroom so you can get a refresh. I was going over the chalkboard last night, and to my surprise, there is so much things that are being put on the blackboard that we are going through now. But I think we have the materials, but we need to set them in their right context so we can utilize it to the full. All right, without any further ado, this is about the UCC, and I think we are studying about it. Lana is giving us some insight, but we can never be too sharp when it comes down to these. Things. It's an hour and
There's a
49.
book about this.
What was that, Nana?
There's, there's a book
Yeah.
with the
This
same
is a
title.
this is an hour and 49, and I would encourage anyone when you get a chance to really, like I do this when I'm going to my bed. I let these things play in my head so I can uh I think it's somewhere downstairs or over that side. All right. So without any further ado, let me play this.
The UCC Connection: How to Free Yourself from Legal Tyranny by Howard Freeman. Proverbs 3 verse 13. Happy is the man that findeth wisdom, and the man that getteth understanding. Patrick Henry, Samuel Adams, George Washington, James Madison, Thomas Jefferson, Benjamin Franklin. We the people, governments are instituted among men, deriving their just powers from the consent of the governed. Page 1. This article has filled in the voids that kept me from fully understanding things. I have found it to be one of the best discussions on freedom and how our government has managed to take that freedom away from us, all the while giving lip service to the Constitution. The title of this article is The UCC Connection. The noteworthy author is Howard Freeman. It is dated September 22, 1991. Forward, this is a condensed, paraphrased transcript of tapes of a seminar by Howard Freeman in 1990. It was prepared to make Mr. Freeman's knowledge and experience available in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. The frustrations many Americans feel about our judicial system can be overwhelming and often frightening. Like most fear, it is based on a lack of understanding or knowledge. Those of us who have chosen a path out of bondage and into liberty are faced, eventually, with the seemingly tyrannical power of some governmental agency and the enigmatic and incredible power of the courts. We have been taught that we must get a good lawyer, but that is becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, the lawyers quickly take our money and then tell us as the ship is sinking, "I can't help you with that, I am an officer of the court." Page 2. Ultimately, the only way for us to ever have a snowball chance is to understand the rules of the game and to come to an understanding of the true nature of the law. The lawyers have established and secured a virtual monopoly over this area of human knowledge by implying that the subject is too complex for the average person to understand, and by creating a separate vocabulary out of English words, of otherwise common usage. While it may sometimes comply complicated to grasp, our lawyers as competent as they would have us believe. Besides, Anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers know procedure, not law. Then answered one of the lawyers, and said unto him, Master, thus saying thou reproachest us also. And he said, Woe unto you also, ye lawyers! For ye lade men with burdens grievous to be borne, and ye yourselves touch not the burdens with one of your fingers. Woe unto you, lawyers! For you have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in. Ye hindered. 33 Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not law. Mr. Freeman admits that he is not a lawyer, and as such, he has a way of explaining the law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in language simple enough that the people could understand, specifically so that it would not have to be interpreted. So again, we find, as in many other areas of life, the buck stops here. The UCC Connection page 3. It is we who must take the responsibility for finding and putting the truth to good use. It is we who must claim and defend our God-given rights and our freedom from those who would take them from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skill, and talents of others. To these ends, Mr. Freeman offers a simple, hopeful explanation of our plight and a peaceful method of dealing with it. Please note that this lecture represents one chapter in the book of his understanding, which he is continuously refining, expanding, and improving. It is, as all bits of wisdom are, a point of departure from which to begin our journey into understanding so that we all can pass on to others more excellent knowledge and hope, and to God, the gift of lives lived in peace, freedom, and praise. I send you forth as sheep among wolves. Be ye therefore wise as serpents, and harmless as doves. Introduction. When I beat the IRS, I used Supreme Court decisions. If I had tried to use these in court, I would have been convicted. I was involved with a patriot group, and I studied Supreme Court cases. I concluded that the SC had declared that I was not a person required to file an income tax, that tax was an excise tax on privileges granted by the government. So, I quit filing and paying income taxes, and it was not long before they came down on me with a heavy hand. They issued a notice of deficiency, which had such a fantastic sum that the biggest temptation was to go in with their letter and say, Where in the world did you ever get that figure? They claimed I owed them some $60,000. But even if I had been paying taxes, I never in the world had that much money, so how could I have owed them that much? Page 4, Section 1. Never argue the amount of deficiency. Fortunately, I had been given just a little bit of information. Never argue the facts in a tax case. If you're not required to file, what do you care whether they say you owe $60,000? If you are not required to file, the amount doesn't matter. Don't argue the amount is an issue of fact. In most instances, when you get a notice of deficiency, it is usually for some fantastic amount. The minute you say, I don't owe that much, you have voluntarily agreed that you owe them something, and you have just given them jurisdiction. Don't be shocked at the amount on a notice of deficiency, even if it's $10 million. If the law says that you are not required to file or pay tax, the amount doesn't matter. By arguing the amount, they will just say that you must go to tax court and decide what the amount is to be. When you get to the tax court, the law issues are all settled. You are only there to determine how much you owe W. They will not listen to the arguments of the law. So I went to see the agent and told him I wasn't required to file. He said, You were required to file, Mr. Freeman. But I had all these SC cases, and I started reading them to him. He said, I don't know anything about law, Mr. Freeman, but the code says that you are required to file, and you're going to pay that amount, or you're going to go to tax court. I thought someone there should know something about law, so I asked to talk to his superior. I went to him and got out my SC cases, and he wouldn't listen to them. I don't know anything about law, Mr. Freeman. Finally, I got to the problems resolution officer, who said the same thing. He said that the only person above him was the district director. The UCC Connection page 5, so I went to see him. When I got to his office, they had phoned ahead, and his secretary said he was out. But I heard someone in his office, and I knew he was there. I went down the elevator, around the corner to the federal building, and into Senator Simpson's office. A girl was sitting there at a desk, and she asked me if she could help me. I told her my problem. I said that the district director is up there. I asked her to call the IRS and tell them it was Senator Simpson's office calling and to ask if the district director was in. I said, if you get him on the phone, tell him that you are from the senator's office and you have a person you are sending over to speak to him. If he is, can he wait just 5 minutes? It worked. He was there, so I ran back up to his office. His secretary met me when I came in and said, "Mr. Freeman, you're so lucky the director just arrived." The director was very friendly and offered me coffee and cookies, and we sat and talked. So he asked me what I wanted to speak to him. If you've never had someone say to you, "I'm from the government, and I'm here to help you, watch out." But we can turn that around and approach them in the same way. So I said, "I thought you ought to know that agents are working for you who are writing letters over your name that you would disagree with. Do you read all the mail from this office over your signature?" The director said, "Oh, I couldn't read everything and it goes out here by the bagful." I said, "There are some of your agents writing letters that contradict the decisions of the Supreme Court of the United States, and they're not doing it over their name, they're doing it over your name. How to free yourself from legal tyranny." Page 6. He was very interested to hear about it and asked if I had any examples. I had some with me, so I got them out and presented them to him. The director thought it was fascinating and asked if I could leave this information with him, which I did. He said he would look it over and contact me within 3 days. 3 days later, he called me and said, "I'm sure, Mr. Freeman, that you will be glad to know that your notice of deficiency has been withdrawn. We've determined that you're not a person required to file. Your file is closed, and you will hear no more from us." I have been waiting to hear another word from them since. That was in 1980, and the last time I filed was 1969. Section 2. The Supreme Court on trial. I thought I had the answer, but when a friend got charged with willful failure to file an income tax, he asked me to help him. I told him they would have to prove that he willfully failed to file, and I suggested that he put me on the witness stand. He should ask me if I spoke at a particular time and place in Scottsbluff, and if I saw him in the audience. He should then ask me what I talked about that day. When I got on the stand, I brought out all of the SC cases I had used with the district director. I thought I would be lucky to get a sentence or two out before the judge cut me off, but I was reading whole paragraphs, and the judge didn't stop me. I read one and then another, and so on. And finally, when I had read just about as much as I thought I should, the judge called a court recess. I told Bob I thought we had it made. There was no way they could rule against him after all the testimony. So we relaxed. The UCC connection, page 7. The prosecution presented its case, and he decided to rest his case on my testimony, which showed that he was not required to file and that the SC had upheld this position. The prosecutor then presented his closing statements, and we were sure he had one. But at the end, the judge spoke to the jury and told them, "You will decide the facts of this case, and I will give you the law. The law required this man to file an income tax form. You decide whether or not he filed it." What a shock. The jury convicted him. Later, some of the jury members said, "What could we do?" The man had admitted that he had not filed the form, so we had to convict him. As soon as the trial was over, I went to the judge's office, and he was just coming in through his back door. I said, "Judge, by what authority do you overturn the standing decisions of the United States SC? You sat on the bench while I read that case law. Now, how do you, a district court judge, have the authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how old they are. You have no right to overturn a standing decision of the USSC in a district court." Section 3. Public law versus public policy. He said, "Name any decision of the Supreme Court after 1938, and I'll honor it. But all the decisions you read were before 1938. He went on, "Before 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge Mr. S. was being tried for is a public policy statute, not public law, and those Supreme Court cases do not apply to public policy." I asked him what happened in 1938. He said that he had already told me too much. He wasn't going to tell me anymore. How to free yourself from legal tyranny.
Anybody hear that piece of gem a while ago? I wonder if it run too fast, because sometimes them things you kind of just run over your head. Anybody hear the piece of gem when it's about 1938? That the court do not work on the law, it work on the policies. Yes, that is how a policy, like a peace officer, is different from a police officer, because a police officer enforce the policies of the corporation. Listen keenly. When you think that you're being governed under constitution, there is no constitution, my brothers and sisters. These are policy makers. And the judges know, and lawyers and the police them know. So this is not about law. This is about policies. So I'm gonna listen keenly, because as I said, I want us to, when we're talking to the agents, we can talk to them in the full capacity. It's not when you're telling that you have rights, you don't have no rights under policy. You have rights under law because laws have jurisdiction. Policies do not have jurisdiction. Get that straight.
Tyranny. Page 8, Section 4, 1938, in the Erie Railroad. Well, I began to investigate. I found that 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year the courts claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar as he walked beside the tracks. The district court had decided on commercial law that this man was not under any contract with the Erie Railroad. Therefore, he lacked standing to sue the company. Under common law, he was damaged and would have had the right to sue. This overturned a standing decision of over 100 years. Swift versus Tyson in 1840 was a similar case, and the decision of the Supreme Court then was that in a case of this type, the court would judge by the common law of the state where the incident occurred, in this case, Pennsylvania. In the Erie Railroad case, the Supreme Court ruled that all federal cases would be judged under the negotiable instruments law. There would be no more decisions based on the common law at the national level. So here we find the blending of law with equity. This was a puzzle to me. As I put these new pieces together, I reasoned that all our courts since 1938 have been merchant law courts and not ordinary law courts. There were still pieces that needed to be added to the puzzle. Section 5. A friend in court. Fortunately, I made a friend who is a judge. Now, you won't make friends with a judge if you go into the court like a wolf in black sheep country. The UCC connection page 9, you must approach him like you're the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is and how he could better uphold the law, or else. Remember the verse, I send you forth as sheep among wolves, be ye therefore wise as serpents and harmless as doves. We have to go into court and be wise and harmless and not make demands. We must be humble and ask many questions. Well, I asked many questions and boxed the judges into a corner where they had to give me a victory or admit what they didn't want to admit. I won the following case, and on the way out, I had to stop by the clerk's office to get some papers. One of the judges stopped and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case, we will visit." Section 6. America is bankrupt. Later, when I visited the judge, I told him my problem with the Supreme Court cases dealing with public policy rather than public law. He said, in 1938, all the higher judges, the top attorneys, and the U.S. attorneys were called into a secret meeting, and this is what we were told. America is a bankrupt nation. It is owned completely by its creditors. The creditors own Congress, they own the executive, they own the judiciary, and they own all the state governments. Take silent judiciary.
Nana Chanel, who them say own America again? Who own this country? I want you to answer. Who own this
Creditors.
country? And who is the creditors? We are.
Yeah.
It is our estate, not their estate. So this is what we're unraveling as when we tell our brothers and sisters that they are the masters and the agents out there for the corporation are the servants, without any disrespect. And it says it. A police is nothing more than a public servant. A judge is nothing more than a public. Once you put up yourself to serve in the public capacity, you're a servant. You're a servant to who? Private. None of us here didn't put up ourselves to go and be public officials. No, we're serving in our private capacity. And you know what? I will come into that.
Official notice of this fact, but never reveal it openly. Your court is operating under admiralty jurisdiction. Call it anything you want, but do not call it admiralty. Section 7. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. How to free yourself from legal tyranny. Page 10 in admiralty, no court has jurisdiction unless there is a valid international contract in dispute. When you know it is admiralty jurisdiction, and they have admitted on the record that you are in an admiralty court, you can demand that the international maritime contract, to which you are supposedly party and allegedly have breached, be placed into evidence. No court has admiralty maritime jurisdiction.
Hold on. There's an international maritime contract, Madam Secretary, that we can ask them in the court to produce. There is, right? Because it just said that a while ago that we don't have a contract until that we're in the court. We need to know how did this contract come about. It must have been an international consignment of maritime agreement. Where is it? If it cannot be produced, that means the court has no
jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb, well, I never knew that I got involved with an international maritime contract, so I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then place the contract into evidence so that I might challenge the contract's validity. They would have to place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are the bankers' slaves. Section 8. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. This is the key behind the buildup of the United Nations as a military force. This is the key to disarming America. This is the key to ending the Cold War. Like now, we have no more enemies that we can melt all our guns. Wrong. The bankers plan to foreclose, and they just don't want their heads blown off while doing it. So they dictate to Congress to get rid of the guns, etc. The reason they don't want to tell everyone that they own everything is that there are still too many privately owned guns in America today. There are uncooperative armies and other military forces. The UCC connection page 11. So until they can gradually consolidate all armies into a world army and all courts into a world court, it is not expedient to admit the jurisdiction of the courts they are operating under. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. Section 9. Jurisdiction. The Constitution of the United States mentions 3 areas of jurisdiction in which the courts may operate. Section 10. Common law. Common law is based on our Creator's laws as initially presented by Moses. Anytime someone is charged under the common law, there must be a damaged party. You are entitled under the common law to do anything you please as long as you do not infringe on the life, liberty, or property of someone else. You have a right to make a fool of yourself, provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action that would prevent a man from making a fool of himself. For instance, when you cross the state line, you will probably see a sign that says, "Buckle your seatbelts, it's the law." This cannot be common law because who would you injure if you did not buckle up? Nobody. This would be a compelled performance. But common law cannot drive performance. Any violation of common law is a criminal act that is punishable. Section 11. Equity law. Equity law is the law that compels performance. It compels you to perform to the exact letter of any contract you are under. How to free yourself from legal tyranny. Page 12. So, if you have compelled performance, there must be a contract somewhere, and you are being made to perform under the obligation of the contract. Now, this can only be a civil directed by action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to serve as the court, you can be charged with contempt of court, and this is a criminal action. Are our seatbelt laws equity laws? No. They are not, because you cannot be penalized or punished under equity jurisdiction for not keeping to the letter of a contract. Section 12. Admiralty or maritime law. Admiralty is a civil jurisdiction of compelled performance, which has criminal penalties for not adhering to the letter of a contract, but this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws are under. Whenever there is a penalty for failure to perform, that is Admiralty maritime law, and there must be a valid international contract in force. However, the courts want to avoid admitting that they are operating under Admiralty maritime jurisdiction, so they took the international law or law merchant and adopted it into our codes. This is what the SC decided in the Erie Railroad case, that the decisions would be based on commercial law and that there would be criminal penalties associated with it. Since judges were instructed not to call it AM jurisdiction, they call it statutory jurisdiction. I looked for statutory jurisdiction in the 4th edition of Black's Law Dictionary. It's not there, so I looked up statute, and under its definition is this paragraph. This word is used to designate the written law in contradistinction to the unwritten law. Foster versus Brown, 199 GA 444, 34S.E.2D, 535-35C Common Law. The UCC Connection, page 13, section 13, Courts of Contract. You may ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, but you must understand that in art. Sect. 10. The Constitution gives us the unlimited right to contract as long as we do not infringe on the life, liberty, or property of someone else. Contracts are enforceable, and the Constitution gives 2 jurisdictions where contracts can be enforced, equity and admiralty. But we find them being enforced in statutory jurisdiction. This is an embarrassing part for the courts that we can use to box the judges into a corner in their courts. We will cover this more later. Section 14. Contracts must be voluntary. Under the common law, both parties must enter every contract knowingly, voluntarily, and intentionally, or the contract is unenforceable and void. These are characteristics of a common law contract. There is another characteristic. The contract must be based on substance. For example, contracts used to read, for $1 and other valuable consideration, I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now, suppose you wrote a contract that said, for 1 Federal Reserve note and other considerations, I will paint your house. And think, for example, I painted your house the wrong color. Could you go into a common law court and get justice? No, you could not. How to free yourself from legal tyranny. Page 14. No substance, no contract.
I would encourage us. I'm gonna put that in the room for us to marinate over it and dissect it more. As you hear, there's 3: equity, common law, and what the other one was that could go into the court. Maritime. All right. So we have some homework to do because this is again when you're in front of the judge. What question do you ask the judge? What court is this? What do you ask the judge in asking him? What court is he presiding over? Anyone can answer me? Huh?
Maritime
Is
equity.
this a court of
What was that again?
Is this a criminal court?
Oh.
Is this a criminal court? Is this a civil court? Is this a court of record?
Yep. Gotta ask the judge that. And when you ask the judge that, the judge have to tell you which one of these court is sworn an oath to uphold. And secondly, license. Is judges licensed, brothers and sisters? Is any of these judges have any tangible license? Because the British accredited what's the last one R for again? Registration, the bar. It is not an international credible organization. It's called the British. So it's owned by the British. So these judges all work for the crown.
British.
They're all crown workers. All crown workers. And do the crown have any jurisdiction outside of the British Empire? Wait, because the British Empire is global, but the jurisdiction of the British Crown lies in British territory. And it's a tricky situation because did you know that America belongs to the British by paper? Yes. All of these corporations are registered. And once they're registered under the fictitious jurisdiction, this is how they take advantage of us. So we're trying to unravel it. So when you're inside of the court, you know exactly how. So before you even reach the court, we want you to know how to deal with nibbles, how to when Officer Nibbles tamper with your estate, get the report that Officer Nibbles has put forward, and then put your affidavits beside that report so it can rebut what Officer Nibbles is going to give to a judge who don't have no jurisdiction over you or in your territory to deal with you. And that is why most cases are dismissed. Most cases that is under codes and statutes are dismissed if our paperwork is in the right format. Our estate is in the right format. Our notification is in the right format. So that is what we are getting at. And I thank Nana Chanel so much for marinating over the traveling and driving and come and deliver today. I know that next week again we will get a more insight. Remember that these are questions that we're asking you and sharpening up the brain for now. So when that time, if it should arrive, we won't have too much of a hassle. We won't have to convince you because you will be well knowledgeable as to what to do. Any question for the Secretary of State or myself? No?
Yeah, which
And
book
since no
that
one has any
actually
question, I just want to say that hold on.
which book did it actually come from?
Which one?
Which which one are you talking?
Which the whole program of what you read now, National, which book did you actually take those pages out of?
Okay, I put it in the chat, in the classroom chat. I think about 2 weeks ago.
Okay.
Okay. I'll look back at it.
It's a kind of long book, and I also the book that the UCC connection book. I put the link for it in Amazon. It's on Amazon for $5.
Good.
I put that in the classroom chat as well.
Yes, I just ordered that.
Okay, I'll order that too as well.
But
Let me see.
I'm also putting what the UCC audio version inside the classroom. You can read it or you can access the audio. We have enough equipment at our disposal to take care of our estate. I love that. Hold on. There it is.
I'm trying to find the book.
It's inside. I've just put that in the classroom. Okay.
What did you put in the classroom?
The tape that the UCC connection, how to free yourself from legal
Oh,
issues. It is the video, the YouTube edition that walks you through it. I tell you, of the last night, I was listening it quite cleanly, and I hey, when I wake up and it stops, let me press back play again. I just want to marinate myself that I can address the situation off the top of my head. If you ask me, I have the answer. So that's how I kind of get it done. Any other question? Okay.
I'm gonna try
Uh,
to find the book again and put it back so it can be at the beginning of the thread. But
okay.
no question.
No question. Tomorrow we have
There it is, 167 pages.
okay. Okay.
Just put the book in the chat again. And it's on WhatsApp.
Okay. All right. Well, it is there. Um, Great class, Nana. And Monday is Memorial Day. But we're still doing our class because we have a lot to do. So I will be having class. And Nana, I don't know what is your Monday like. I want to have a Marcus Garvey meeting, but I'll have to confer with you off the year.
What did you say, honey?
Marcus Garvey meeting. I have some minutes.
We're going to be busy.
All right, then I'll reschedule that.
He said, how long do you need me for?
Well, we usually just keep it for an hour, and then you go, because now that we have trashed out most of the things, we want to launch the promotion for the 1st of June. So I have the commercial and so that I want to put across. And we have some letterheads where we have to post out some email. Nigel had made a suggestion that if time permit, he would want to come over. I don't know how best it would be. I'm not pushing the momentum because I know that cash is hard, but if anyone wants to come, the opportunity is open. But
he said only because it's you can have an hour.
Yes. Well, I'll try to make it for 10 o'clock on Monday. The little man is out of school now, so he's going to be around me, and I plan to go fishing with him and camping and all of these things. So if I have to carry my machine on the road and do what I have to do, fine. But I'm going to spend some quality time with him this summer so he can get in contact. There's nothing else right now. So tomorrow we have meeting. I look forward to seeing if you can make it, and invite a friend. Invite someone that need to be in the limelight. Carry a family member or somebody. But we shall be.
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 We shall